Welcome to the fifth episode in the first season of Justice Center Weekly, a half hour with the Justice Center for Constitutional Freedoms. Today we have with us lawyer Chris Fleury, who works with the Justice Center, representing Harold Jonker. Jonker, a trucker and company owner from Niagara, was recently criminally charged by the Ottawa Police Service with offenses relating to his participation in the Freedom Convoy protest in Ottawa back in February 2022. First, Chris, welcome to the show, and maybe we could get you to introduce yourself before we turn to the topic of Mr. Jonker. What's your 1-minute bio?
Sure. Thanks for having me, Kevin, and good afternoon, and good afternoon to all of the listeners out there. So right now I'm a lawyer with the Justice Center for Constitutional Freedoms. Before that, and sort of going back to law school, I'm someone who I would say always had the inclination that I was going to be, for lack of a better word, fighting the power. There was an initial time where I thought I was going to be an employment lawyer fighting for workers. I ended up in a program at Osgoode Hall where I was working with the legal aid clinic through an internship. I ended up articling in criminal law, so doing criminal law at the internship and then articling at criminal law, doing a lot of defense work. Ended up finding my way into plaintiff side personal injury and suing insurance companies on behalf of persons who had been wrongfully injured or denied insurance benefits, which seemed like a great career for about 6 or 7 years. I was very happy doing that, and then COVID happened, and it became quite apparent to me. I'm not going to tell you my sob story, but it became apparent to me that there were more important battles that needed to be fought. And I reached out to John Carpe and had a conversation, and it took me a little while to wind down my practice at that point. But then in 2023, I started with the Justice Center.
Okay, welcome aboard. Let's turn to the case at hand then. How's your client doing?
Harold is quite upbeat, which is no shock to, I think, anyone who knows him. I had the pleasure of meeting Harold for the first time last week. He's someone who he takes the charges seriously, but every time that I'm on the phone with him, I find him cracking jokes. He is someone who, and again, this is not a shock to anyone who knows him or has watched him on media. He's a faithful Christian, and he finds solace in that, I think it's fair to say, and that's helping him keep his head straight while he's facing these serious charges.
Right. Well, these criminal charges are different from other actions in the Justice Center, which was involved with Mr. Jonkers. Was he facing any criminal charges in the past? Could you briefly outline the various past actions he was involved with? They were mostly civil actions. Is that right?
Yes. So Mr. Jonkers has no criminal record. He's presently facing, and I'll just go through the current charges, or the charges that I'm representing him on. He's facing a charge of intimidation by blocking or obstructing a highway. He's facing a charge of mischief that's interfering with the lawful use or enjoyment of property. And he's charged with, so that's 2 counts, and he's charged with another 2 counts of counseling those 2 same offenses. So he's accused essentially of encouraging people or facilitating those 2 offenses. So that's quite separate and apart, you're right, from some other legal cases that Harold has going on. So he has, and these I'm a little bit less familiar with because I'm not his lawyer on those particular cases. But I do know that he's brought an application for judicial review in relation to some sanction that he faced in his role as a local town councillor. So that I understand is ongoing. He's also a defendant in the class action lawsuit that the citizens of Ottawa are prosecuting as against the truckers as a whole. And I understand that he is now a named defendant in that civil action.
So yeah, he's right across this whole thing, at least with the Justice Center anyway. He seems to be involved. And these charges, of course, came just recently, I understand it, the ones that you had just enumerated, the criminal charges.
That's right. Yes. So it was just last week that I first became aware of it. That he reached out to me, and it's really just been the last few weeks that he turned himself in. And yesterday, in fact, was the first court date.
May 10th, that was his first court appearance on these charges. How did that go?
Well, it's perhaps it's beneficial to your listeners to just understand a little bit about what a first court date in the Ontario Court of Justice usually is, just so that I can situate it. The short answer is that
Okay.
it was totally uneventful, but usually, essentially, there's two types of first court dates. One would be if the issue of bail is to be determined, and in that case, you would be held by police following your arrest, and you would appear before a justice of the peace within 24 hours. And the issue for the justice of the peace for that day would be to determine whether or not you can be released prior to trial. So in Harold's case, because he is just self evidently not a danger to the public, is not going to go on to commit criminal offenses, and has every reason to show up for his court dates, he was released by the police officers on an undertaking. And that's just a promise that he made to the police officer. He signed a document that said that he would abide by certain conditions, which is very usual for persons in his circumstances. Nothing unusual about that. So, what the undertaking said is that the first court date would be yesterday. And when a person in those circumstances shows up for a court date at the Ontario Court of Justice for a first appearance, in many cases they don't have a lawyer. I would say in most cases they don't have a lawyer. The Justice of the Peace will try to make sure they understand what's going on. If they do, they ask them, "Do you have a lawyer?" And they say no. And they say, "Well, maybe you should think about getting a lawyer." And the person says, "Oh, well, that sounds like a good idea." And they get an adjournment for 4 to 6 weeks to get a lawyer. Um, and that will continue on so that essentially the preliminary steps in the criminal process can play out. And that means getting a lawyer, getting a copy of the disclosure package, reviewing that with your lawyer, speaking with the Crown Attorney, and then deciding where things are going to go from there. That whole process typically takes about 3 months. Harold was quite prepared, and by retaining a lawyer quickly, he got a head start in terms of that process. So yesterday, we had already requested disclosure. In fact, the Crown provided us with a preliminary disclosure package yesterday, and the matter was adjourned into June with the idea that it would give us some time to review that disclosure, review it with Harold, and speak with the Crown Attorney if we're in a position to do that.
Okay, yeah. I guess without getting too much into the specifics of the disclosure package, I just want to mention that a lot of the stories that I read about these charges mentioned that Harold was involved in a documentary that was released by True North, and he featured prominently in that. I wondered if that was mentioned at all in the disclosure, whether the police were using this as sort of a way to investigate,
So I want to emphasize that we're at a very early stage, and it was
Sure.
about 400 pages that were provided yesterday. I had a chance to skim through them yesterday, but I'm still working through them. I don't recall that documentary specifically, although what I can say is that a very large part of the police investigation and of the case against Harold more generally is what the police would call open source media, videos on YouTube, other platforms, by, in some cases, independent media, in some cases, live streamers who are streaming the convoy and that sort of thing. So there's a lot of what the police call open source video evidence.
Yeah. The reason I was asking about that is I know that a lot of participants in the Freedom Convoy, I can't say a lot necessarily unless I can give a number, I suppose, but many had charges dropped due to things like police not having notes and things like that. That's kind of what I was wondering about, because we saw so many charges not being pursued because the police didn't seem ready to go ahead. Is there any indication that they're a little better prepared here? 400 pages, I suppose so.
Again, I don't want to comment too much on the specifics of the
Okay.
disclosure, but the I would say that just by virtue of them bringing the charge, we're talking 14 or 15 months after the events that are at issue. It speaks to the seriousness that the Crown is taking, and consequently that we are going to be taking in terms of his defense.
Okay. At this point, do you have any idea of what kind of defense you'll be presenting? We, of course, talk an awful lot here on podcasts related to the Justice Center about the Charter of Rights and Freedoms. Are we looking at freedom violations, anything like that involved here? Any charter type things involved?
Again, it's difficult to say, and I don't want to comment too much
Too early.
At this very early stage in terms of what our defense strategy is going to be. Right now, we're simply reviewing the disclosure. We're going through the normal criminal court process. That includes the videos haven't even been provided yet, so we're going to be. I've already followed up and requested copies of those, which I'm sure we'll get in due course, and we'll be reviewing those and obviously speaking with Harold about our opinions.
Oh, okay.
The other piece, perhaps, that might be helpful, and this shouldn't come as a shock either, is that in receiving an initial disclosure package, it's usual to get what's called a Crown screening position, and the Crown screening position in this case, it should again come as no shock to anyone, is jail time. So the Crown is seeking jail time even on an early plea for Harold. Given what I've read simply as a concerned citizen reading about Miss Leach's and Mr. Barber's cases and what happened in terms of their bail hearings, etc. Again, I wasn't shocked by that, and I don't think Harold was either.
But there was no bail requested here, right? This was a no bail case, at least as of yesterday, right?
That's correct. Yes, he was released on recognizance.
And no conditions either. That's one of the things that came up in those other cases you referenced, were heavy, onerous conditions, at least initially.
There are, on any undertaking, there are some conditions. Standard conditions, I'm not going to comment on Harold's conditions, but standard conditions would be to appear for court, to appear for fingerprinting, to let an officer know about a change of address. Those sorts of conditions are what you'd usually expect on an undertaking. I can say that.
Okay, all right. So fairly normal to this point, I guess, without getting into too many details, which obviously we can't get into. Any other particulars you want to bring up in this case?
Yes, Kevin. So as I mentioned, there's been a 14 or 15 month delay in the time period between, as I understand it, the events that are at issue, which are relating to the Freedom Convoy in Ottawa, and some statements that Harold is alleged to have made shortly thereafter. So we're talking 14 or 15 months from then until now, where Harold is charged. The delay has the very real potential to prejudice his defense, and the reason is that, as we all know, memories fade, witnesses become harder to track down. Videos or evidence can get digital evidence can get deleted, and this is all, I would say, speculation at this point. I'm not able to say for certain that any of this is the case, but these are concerns that we have, given the delay to date, that it is going to impact his ability to make full answer in defense.
Okay, is that a standard concern when you're looking at a situation like this one where the charges are laid some 14 months after the fact? Is that pretty much a standard concern?
Well, it's a little bit unusual to have charges. I would say it's quite unusual, actually, to have charges that are where the police know about Harold. He's someone who's in the media. Where there is some investigation into him in particular happening in 2022, and then a delay until 2023 in charging him. And I don't know, again, I can't emphasize enough that we don't know what the reason for this delay is at this point. But it's unusual. You think of the standard case as a person facing criminal charges, say they drove while impaired, or they're accused of domestic violence or something like that. And in that case, the police find them, they arrest them and lay charges, and the case continues from there. So it's immediate. In some cases, you have, for example, again, talking about criminal charges, you might think of like a victim of domestic violence might wait to make a complaint. And in that case, maybe it happens months or years later. But once the police, they conduct their investigation relatively quickly, and then they lay charges as soon as they believe that they have grounds to do so. This is it appears to be unique, and again, we'll wait to hear from the Crown in terms of what the source of the delay is.
Okay, just to clarify, there you said unique. You're speaking about the delay. The delay is unique here.
It is. I would say it's fair to say that it is unique. It's not common that you would see a delay of this length, where the police and the Crown were aware of Mr. Jonker, and I'm not aware of any new details that would have been available or would have come to light within, say, the last 6 months, the last 8 months, that the Crown just became aware of. I'm just not aware of that. But again, we're going to wait to see. We're at very early stages, and we're going to wait to see what the explanation is.
Oh, okay, fair enough. One of the things that caught my eye was this idea that, at least to the way it's portrayed in the news stories that I saw, is that, this was declared an illegal event, and therefore, he's participating in an illegal event. And this was something that came up at the Public Order Emergency Commission hearings. There was lots of contention about when it became an illegal event, and a lot of people, like myself, assumed it became illegal after the 14th, the Emergencies Act. It was made illegal. Is that an issue here at all?
So, Kevin, the issue in Harold's case is whether or not he's guilty beyond a reasonable doubt of these 4 separate offenses that I was laying out, whether it's mischief by obstructing property, whether or not it's intimidation by blocking or obstructing a highway, or counseling, either of these 2 offenses. And the issue, it's going to rise, his case is going to rise or fall in terms of whether or not he's guilty or innocent beyond a reasonable doubt of, I should say, guilty beyond a reasonable doubt of these offenses. One thing that's important to emphasize is that the emergency declaration, first of all, he's not charged with breaching any order made under the Emergencies Act, but that also did not deem it illegal to protest against the government's COVID-19 mandates, and that's important to emphasize as well.
Oh, okay. So just lay that out. The Emergencies Act didn't take away his right to protest, and we can contend that these things that he was doing was a legitimate protest. I think that's what I'm thinking you're saying.
Again, I'm not going to comment on the charges
okay.
and specific defenses that he's going to make, but again, it's going to rise or fall. The case is going to rise or fall on whether or not they can prove that whether or not the Crown can prove that he's guilty beyond a reasonable doubt of these charges. And he's not charged with breaching an order under the Emergencies Act.
One of the things I wanted to ask you was regarding other charges towards other people, because of course Harold wasn't the only trucker there, and so are you aware of other people perhaps in his orbit? He had truckers with him, or perhaps other truckers that are facing similar charges. This is. It was reported that he was the one charged here, and I don't think I've seen news stories of other people being charged with similar offenses.
So I defend a couple of other individuals who were charged in the context of the Emergencies Act and the protests in Ottawa. Neither of those individuals who I defend were actually alleged to be truckers. They didn't drive a truck to Ottawa or that sort of thing. We are watching, and I am aware that a number of the leadership, if I can call them that, of the convoy protest do have trials coming up in September in Ottawa, and we are going to be watching that quite closely to see how the courts interpret, particularly the mischief charges and counseling mischief. Mr. Jonker's charges are obviously different than, for example, Ms. Leach's charges or Mr. Barber's charges, or I should say the allegations are different. And just like in any case, the allegations are going to be a little bit different. The facts are a little bit different. So they may not be determinative, but we're going to be watching those cases closely just to see how the courts react to their defense strategy, and how the courts interpret the charges and mischief and counseling in the context of the Freedom Convoy.
Okay. Well, I guess that brings up the final question, which would be timeline. What are we looking at here? You're going to be watching these other cases in September. I assume you're not going to court before that. What are we looking at in terms of timeline for these criminal charges?
It's very early to say.
Mm-hmm.
The Crown, because of this delay, the Crown is forced to proceed indictably, which means that Harold has some rights that he may not have, or he would not have if the Crown was proceeding summarily. It doesn't include a preliminary inquiry, unfortunately. So there are, but it could include, for example, a trial in the Superior Court of Justice. We haven't made, we're at such early stages that there's no determination that's been made at this point. I'll say this, though, that in any criminal case, there's a decision to be made by the accused person, and that decision is whether or not to take the case to a contested trial or whether or not to resolve the case with the best deal that they're able to negotiate, and usually that's what's called a plea deal. In some cases, there are ways to resolve things without a plea. But from my understanding, none of these cases involving the Freedom Convoy have resulted in plea deals that I'm aware of. I believe the vast majority of them have headed to trial, and my sense is at this point is that that's where Mr. Jonker's case is headed. I believe that most of them have gotten to trial within a what the courts would call a reasonable amount of time, meaning within 18 months. So I would expect that around that time period, we're going to be trying Mr. Jonker's case.
Okay. Just to clarify here, then, because I'm a bit confused, did he plead yesterday? Did he plead yesterday in his court case?
No, there's no expectation to plead guilty.
Okay.
Guilty on a first appearance.
Okay. I wasn't sure. Okay, well, that's great. Thanks a lot for filling us in. There's a lot of unknowns at this point, of course, but we're glad to hear that you're up on it and you've got some disclosure. They didn't give you any timeline for the rest of the disclosure, did they? I suppose that's kind of open-ended.
No, I'm not really expecting delays. That it's been pretty quick, to be frank, in terms of getting the disclosure that we do have. The videos, it's not unusual, I should say, to have some paper disclosure come first and then videos follow shortly after. But that, again, it'll come in due course.
Good. Okay. Well, glad to see he's in good hands. Thanks a lot, Chris, for taking the time to explain to us this situation at this particular time, and I'm sure we'll keep the audience updated, and hopefully we'll talk to you again soon.
Great. Thanks a lot, Kevin. It's a real pleasure.